Trump dam just broke. A federal judge ruled this week that a non-disclosure agreement that the 2016 Trump presidential campaign required its staffers to sign is invalid. The judge's ruling said that the, quote, non-disclosure provisions' vague, overbroad, and undefined terms also render it unduly burdensome. It is difficult, if not impossible, to know whether any speech might be covered by one of the broad categories of restricted information, whether that speech might relate to one of the several hundred potential subjects of the non-disclosure provision, or whether that speech may relate to a matter that President Trump will determine is confidential. Because the effect of these burdens is to chill the speech of former campaign workers about matters of public interest, the non-disclosure provision is harmful, and not only to them, but also to the general public. And joining us now is one of the lawyers who convinced the court that the Trump non-disclosure agreements are invalid, Attorney David Bowles. Thank you very much for joining us tonight, Mr. Bowles. So you joined that winner's circle of lawyers who have beat Donald Trump in court. The non-disclosure agreement that I saw used in this case that you're working with seems to be lifted directly from the Trump company, their regular business non-disclosure agreement. What made you think that could be invalidated as applied to campaign workers?
Well, thank you for welcoming me to the winner's circle, but also it wasn't just me. It was a big team effort, and we do appreciate that. What made me think that it could be invalidated is that if you read it as an attorney who reads contracts and litigates contracts, it is obviously massively, ridiculously overbroad. The terms are undefined. For example, one of the terms that defines confidential information in the agreement is anything Mr. Trump says is confidential. As an attorney, as a human reading a contract, you can't possibly know what that means. One of the judges of the First Department Court of Appeals said, this thing has holes in it you could drive a Mack truck through. And he's right. And that's exactly what Judge Gardeffi said in this recent opinion.
What do you think this is going to mean? This was for one individual plaintiff. Will it apply to everyone who worked in that 2016 campaign?
It will ultimately. You are right that this only applies to our main class leader, Jessica Simpson, right now. But this is a class action lawsuit. The purpose of this lawsuit is to unwind all of these NDAs for every single person in the Trump campaign who signed what. Now, our best information is every single person that worked for the Trump campaign, from the highest senior advisor to the lowest volunteer, signed the same agreement. Now that the judge has done the hard part, 36 pages to invalidate Jessica's NDA, it's almost certain that the NDA will fall for all of the other campaign workers, and that ultimately is our goal.
Do you have any sense of what stories we might then learn when everyone working in the 2016 campaign realizes legally those non-disclosure agreements are meaningless?
I don't yet, but just imagine this. Let's say we don't know yet how many of these things were signed because we're still working on that in discovery. Let's say it was 500. Let's say that 10% of those people have a story to tell. That's 50 stories, and I want to hear them, and I'm sure you do too.
David Bowles, we want to hear those stories as you collect them, and thank you very much for joining us here tonight. We really appreciate it.
Thank you so much for having me.